I want to spend a little time here reviewing some of the basics for getting copyright protection. You know, a lot of people believe that in order to get copyright protection, you have to register your work and put an appropriate notice on it with certain symbols and statements. I imagine that some of you came into this course with this belief. But, strictly speaking, this is not true. Rather, what do you have to do to be protected by copyrights? The answer is nothing. All you have to do is put your original expression on some tangible medium, such as on paper or a computer drive, and you've got it. And this is true in the United States and, as far as I know, in every other country around the globe. So, no, you don't have to register to be protected. Long ago, you did have to register with the Copyright Office, but that was changed in 1978. And no, you don't have to put a copyright notice on your work. Again, there once was a notice requirement, but that was removed from US copyright law in 1989. But having said this, I have to also tell you that there are very good reasons to register your work and to put on the simple notice, which I think most of you know is a C with a circle around it, the year of first publication, and the copyright owner's name. Okay, so why register? Let's start with this. Unlike with patents, copyright registration is cheap and easy. You don't need all those fancy lawyers and everything. You can do this yourself. And the fees are really low. We're talking like $45 to $65. You can now even register a bunch of blog posts or other kinds of short electronic statements with one registration for that $65 fee. These are the fees, by the way, if you register electronically. If you do it with paper, it's going to be a little bit more. And as I said, you don't need a lawyer. The forms are easy and just require things like the author's name, the title of the work, and, if the work has already been publicly released, the year that it was first published. You will also have to submit a copy of the work, which you may be able to do electronically. Given that it's so easy and relatively inexpensive to register, the bottom line is if there are any realistic benefits that might arise from registration, then it's probably worth doing it. And so let me tell you some of the reasons that registration might be useful. First, there are some procedural advantages that one may get with registration, such as with the burden of proof in lawsuits. Registration also is needed to enlist the help of Customs and Border Protection to block infringing imports. But here is something else. While it is true that you don't have to register to obtain copyright protection, if somebody ever infringes your rights and you end up having to sue, then the law requires that you register before you file the lawsuit. So, looking down the line, you will have to register someday if things get nasty. So then the question is whether you should wait until there might be a problem, or is there a reason that registering early might be beneficial? And yes, there are ways that you can benefit from early registration. And I always emphasize these two items to clients when I recommend registration. The first regards the amount of money you might get in a lawsuit from someone who infringes your copyright. So, in this regard, copyrights are somewhat like patents. You can use almost any measure of damages that makes sense. For instance, here are the sales I lost because the infringing copies were on the market. Or, here are the typical royalties I negotiated with other companies that licensed to use my copyrighted material. Or, here is the money that the infringer made from using my work, and he should have to fork that over. So, basically, the measure of damages is how much did I lose, or how much did they gain? The big problem with damages is that you have to prove the losses or gains in court. And that can be difficult with copyrighted content. Just for instance, suppose you take a really nice picture, let's say of a sunset in Shell Beach, and you post it on your private Instagram account. Then someone takes a screenshot of the photo and posts it on their public account. That person also prints it and uses it as a background for a commercial advertisement. And then others begin to share it on their public accounts and whatever. You know how this goes. Now, try to figure out for me how much you lost because of these actions. How much royalty income did you lose since you've never licensed your photos before? How much did you lose in sales given that you never previously sold your photos and weren't intending to market this one? How much did the infringers make from posting or using your work? Did they attract viewers that led to income? Did the ad produce sales? Just realize that proving damages can be a really difficult hurdle when seeking compensation for copyright infringement. You really don't have to look any further than the case that Universal brought against MP3.com. How much did Universal lose in sales because MP3.com set up the service? Frankly, Universal may have gained sales because MP3.com's service made CDs more convenient to play in different places. And the loss of potential royalty income is similarly not clear for such a novel use. Also, if you try to base damages on MP3.com's profits, well, the company didn't charge a subscription fee. Instead, it was trying to build a customer base, which it might later monetize through advertising or something else. So, I don't know. Proving damages might be really difficult here, even for a sophisticated recording company. The Copyright Act solves this problem by providing what are called statutory damages, which allows a judge to award an amount of money that seems reasonable under the circumstances, even without any proof of actual damages. But here's the rub. In order for you to be entitled to receive statutory damages, you have to register within 3 months of publication, or before the infringement. So you can figure this out, but assume you are casual with posting your photos, and then later on learn that people have been screenshotting, sharing, and using your content. You decide to chat with your attorney to determine if you can get any money for what has happened. Well, your lawyer will let you know that you have to register before filing suit. And if it's been over 3 months since you posted, you will have to prove the actual damages. And good luck with that. On the other hand, if you had registered your photo within 3 months of your publication, then you would have preserved your ability to collect statutory damages, even though you discovered the infringement and brought suit much later on. And this in turn will provide you some time to breathe when you discover that there are infringements, and will increase your negotiating posture as you try to settle the issues. How much can the judge award for statutory damages? The standard amount is anywhere between $750 and $30,000 per copyrighted work, as the judge believes is just. And just to be clear, it's not like you can get 30 grand per copy. It's 30K for all the copies or other violations of one particular work. Now, it's usually not that difficult to determine what one work is. A novel or a painting is one work. But questions sometimes arise when you're talking about something like a CD that has 10 songs on it. In one sense, the album might be the work, and the limit would be $30,000 for the infringements. But it's also possible that each song could be recognized as a separate work, which would raise the amount to $300,000 per that CD, at least with 10 songs on it. At the moment, there's not a definitive answer to which of these approaches is right. Some courts apply statutory damages per CD, while others base them on each song. Okay, the standard maximum for statutory damages for each work is $30,000. But if the copyright holder can prove that the infringement was willful, then the court can award up to $150,000 per work. This means that the defendant knew that he was infringing the copyright or acted with reckless behavior. Anyway, when you watch a movie and you see that copyright notice, this is where that warning about being liable for up to $150,000 comes from. So, in the MP3.com case, Universal asked the judge to award statutory damages, and the judge determined that MP3.com willfully infringed its copyrights. Well, maybe. In my view, the fair use argument is not totally ridiculous. And so it is possible that MP3.com thought that its service might be lawful. If so, then it's hard to say that it knew that what it was doing was wrong and it proceeded anyway. But the judge didn't see it that way, and frankly, he was there hearing the testimony. So perhaps at the end of the day, the company really did act with callous disregard for Universal's rights. In any event, since the judge determined that the infringement was willful, the range he had to work with was between $750,000 and $150,000. Okay, well, it turned out that the appraisal of willfulness didn't really matter because the judge determined that MP3.com should pay $25,000 for each Universal CD that it unlawfully copied, a number that is within the standard range. And how did he come up with that figure of $25,000? In his ruling, he stated that he was guided by several factors that led him to a just result. What were those factors? One factor in favor of a large award was the size and scope of infringement, given that MP3.com copied thousands of CDs. Thus, the potential for significant harm was high. Another important factor, according to the judge, was MP3.com's size and financial assets, since the damage award should be sufficient to deter the company in the future. Also, the judge considered how the ruling could serve as a general deterrent to others who might be tempted to engage in similar unlawful activities. He worried that if he set the bar too low, then others might be tempted to push the envelope, knowing that their potential profits would outweigh the cost of potential statutory damage awards. The judge also noted that it would have been pertinent if Universal had provided proof of losses from the infringement. Universal didn't have such evidence, which is why it asked for statutory damages. But had there been proof of actual harm, then that might have given the judge a further reason to increase the final figure. Okay, so the judge wrestled with those issues and a couple of others and landed on $25,000 per CD. Recognize that there's no rocket science or mathematical precision here. The judge or jury just kind of picks a number that feels right. And that's the beauty of statutory damages. They open the door to potentially big awards based on pretty nebulous notions of fairness. And as you can imagine, they can also be somewhat frightening to defendants who must worry where the spinning wheel might land. The end of the MP3.com story is that there were still questions about the number of CDs that qualified for protection. Whatever that number was would be multiplied by $25,000 to get the total award. The parties then settled for around $53 million. Just to be complete here, 5 recording companies sued MP3.com at the start, and the other 4 settled for about $20 million each before the judge determined the statutory damage amount. Thus, as it turned out, Universal appeared to make the right call to roll the dice with litigation. I'll give you Another example of a good call: when the recording industry sued an individual engaged in file sharing their music. It seems likely that actual damages probably would have amounted to a few $1,000s, but the industry requested statutory damages. The jury concluded that statutory damages were $80,000 per song, and so the total came to almost $2 million in damages for 25 shared songs. Now, this startling amount ultimately was reduced on appeal, but I think you get the point. Statutory damages can be very powerful indeed. Before moving on, I should mention one other aspect regarding statutory damages. The Copyright Act allows the judge to reduce statutory damages to as low as $200 per work when the defendant engaged in innocent infringement. What is innocent infringement? It's when you don't know and have no reason to believe that you are infringing a copyright. In a moment, I'll review the reason to put on a copyright notice, which primarily is to cut this claim off at the knees. Okay, you want to register early to be eligible for statutory damages. Another reason you should consider registration has to do with attorney's fees. As you probably know, the general rule in this country is that each side has to pay for their own attorneys, even if they win the lawsuit. However, the Copyright Act provides that a judge, at his discretion, may award reasonable attorney's fees to the prevailing party. Does this mean that if I sue someone for copyright infringement and I lose, I could have to pay for the defendant's lawyers? And the answer is yes, you might have to, because that person who I sued prevailed in the lawsuit. Okay, but what if I win? Can I get the infringer to pay for my lawyer's fees? And the answer is again yes, but only if I registered within 3 months of publication or before the infringement. The same standard that applied with statutory damages. And when might the judge exercise the discretion to award attorney's fees? That's going to depend on a lot of things, but certainly when the other side was objectively unreasonable in their position. That is, the one suing marched forward with the lawsuit despite having an incredibly weak allegation, or the defendant refused to settle when infringement was pretty darn clear. Let's put this together for a moment. Suppose you have a copyrighted work and you become aware of infringements. You contact an attorney and recognize that the fees can add up very quickly. Indeed, estimates for average copyright litigation costs are all over the map, but I've seen numbers from $290,000 up to nearly $1 million. If you did not register as required, then you will have to pay these attorney's fees, even if you win. Thus, the courts will have to award significant damages just for you to break even. And without registration, you're going to have to prove these amounts because statutory damages will not be available. On top of this, if you lose, then it is possible that you will not only have to pay for your own attorneys, but those for the other side as well. Therefore, after you do the risk-benefit calculation, you may decide to drop the matter or settle for much less than you might deserve. On the other hand, if you do register sufficiently early, then the calculus changes significantly in your favor, as you will now be entitled to statutory damages and possibly attorney's fees. This means that you are in a much better position to defend your rights should problems arise. So again, you don't have to register, but there are often very good reasons to do it anyway. Having said that, there are still going to be times when the benefits from registration won't be enough to convince you to actively enforce your rights. You know, damages from copyright infringement are often pretty small. Somebody distributed some music or posted a photo or whatever. Your attorney is still going to be expensive. But the judge might not award attorney's fees and could rule on the low end of statutory damages. Thus, you might be reluctant to proceed. For this reason, Congress passed legislation to address this problem in December 2020. Basically, the law establishes a copyright claims board, which is like an arbitration panel within the Copyright Office. And its role is to hear cases involving relatively small sums of money. We're talking maximums like $30,000 in damages, or statutory damages of less than $15,000 per work. And it's designed for individuals to bring cases themselves without attorneys, sort of like daytime TV court shows. Anyway, I think it's a really good idea. All right, I want to finish this up quickly now. Yay! The last topic is about notice. And as I've already mentioned, you don't have to provide any kind of copyright notice on your work to enjoy copyright protection. However, I still advise that you display one. Why? Because if you sue for statutory damages, the defendant may argue that he had no idea that anyone claimed a copyright interest in the work, making him an innocent infringer. If the judge or jury buys this argument, then the statutory damage award may be reduced to as little as $200 per work. However, if the work appropriately displays the copyright notice, then this argument won't hold water. Notice also may strengthen your hand if you argue that the infringement was willful. Thus, providing notice is a cost-effective way to enhance your possible return from statutory damages. Okay, one last thing I'll mention just for completeness. How long do copyrights last? The answer is a really long time. For individuals, it's the life of the author plus 70 years after that. And for a company, it's typically 95 years from the date of publication. Oh, it could be longer, like 120 years from the date of creation, if the company didn't publish it for a while. But no need to worry about that. Just know that copyrights go on for what will seem like forever. Well, that's it. Next on the agenda is copyright infringement. So, goodbye.